Hello, everybody. I always feel tempted to be like the Simpsons doctor and say, "Hello, everybody." I can't really do his voice. Anyway, um, I miss you all since I didn't get to see you on Monday, but I'll see you on Wednesday and Thursday of this week. Quick plug for the certificate program. I hope you all apply. You all so far seem to have the kind of work ethic and ownership taking that we love to see in the program. But for now, we're going to switch to some quick slides, or well, a short presentation on standard of review. Ooh, exciting stuff. All right, see you soon. So the standard of review is like the lens through which the appellate court views the problem in order to make their determination. These are the most common standards of review that you see out there. They're de novo, clear error, arbitrary and capricious, and abuse of discretion. We'll talk more in a moment about how you determine what the standard of review is for your motion. For now, let's take a quick dive into each of these standards of review. These are all appellate standards of review, by the way. So de novo means clean slate. It's as though the trial never happened. Typically, you see this standard applied to questions of law, which would be either situations where the court is debating over what the rule actually is, or regarding the application of law to fact. Next, we have that clearly erroneous standard. And the reason that I have someone bowing here is that this is a very deferential standard. So in contrast to that abuse of discretion standard in contrast to that de novo standard we just discussed where it's as though the trial never happened, in this standard, the court owes deference to the trial court. And so it typically applies to factual findings, and the court will overturn those only if they are clearly erroneous based on the record. Arbitrary and capricious tends to be more of a standard that is applied to administrative cases, and it means without reference to any sort of rules or guidelines, that they're just kind of out there doing whatever they want. If a judge is out there just doing whatever they want without reference to any sort of rules, then under the arbitrary and capricious standard, they could be reversed. And then finally, we have the abuse of discretion standard. This standard you typically see either in cases where the lower court has a mandatory duty to perform and they fail to perform that mandatory duty, or that they were explicitly prohibited from doing something, and they abused and they did that thing that they were explicitly prohibited from doing, or in a situation where maybe they were deferred or allocated some discretion and they went outside the bounds of that discretion and abused it. So, which one of these standards applies in your case? Well, since in this case we have a motion to suppress in the 11th Circuit, we're going to do a little bit of research in the 11th Circuit. You want to look and see what the court what standard the court has been using to determine motions to suppress, particularly in situations where there was a grant of a motion to suppress. Okay, I'm back. Well, I tried to go to Westlaw and do a search, and it just kept locking up on me. So hopefully we'll be able to do that in class. If, worst case scenario, I can have you all sign off of Zoom, do the exercise, and then sign back on to Zoom for us to go over it tomorrow in class. For now, we'll just look at the standard of review in one of those appellate briefs you have here. Taking a glance at it, I think this is actually wrong for a 12b6 motion. I would want to double check. He says, he or she, I can't remember who wrote this brief now, says that the standard of review is de novo. I think in a 12b6 motion that it's de novo for matters of law and clear error for findings of fact. I would want to double check that, so don't quote me on it. But, you know, this is what that section looks like. He would just want to edit it, he or she would just want to edit it to reflect the correct standard if I'm right about that. You would want cites at the end of each sentence. And I notice here this student did say that the allegations are construed in the light most favorable to the plaintiff. Well, that is definitely not the de novo standard because the de novo standard is a clean slate. That sounds a lot more like clear error. That is language that if it were to show up, you would want to include. I want to know if there is a factual dispute, in whose favor should the appellate court resolve that? In whose favor should they resolve credibility concerns? So if you have any kind of standard out there indicating that, I would want you to include that. This student did cite Twombly, which is one of the, well, it's one of these seminal cases for 12b6 motions, so that's good. All right, I look forward to seeing you all on Wednesday.